Good afternoon, Judge Siwendu.
Good afternoon, Chief Justice and the Commission.
How are you this afternoon?
I'm as well as I can be.
Okay, no, that's all right. Thank you very much for availing yourself for consideration for appointment to the SCA and for coming to this interview once again.
Thank you for inviting me.
Yes. We interviewed you not so long ago, so a lot of things about you are still fresh in the minds of some of us. But in any event, you have given us a lot of information in the questionnaire and in other documents that are in the bundle. So we are aware, and everyone is taken to have read the information. We are therefore not in the interview going to try and cover all the information that is there. We'll simply focus on certain aspects on which we would like to hear what you have to say.
Yes.
We will ask you questions aimed at satisfying us as to what extent you satisfy the selection criteria that we have adopted for the selection of judges to various levels of the judiciary. So nobody wants to block you from elevation, but we all simply want to make sure that we are satisfied about your meeting of those criteria. So I will ask you some questions, and then I will allow the president of the SCA to ask you questions, then the minister, and then other commissioners. So let's start. You hold 3 degrees, is that correct? That is Bachelor of Social Science and the Honors of Social Science and LLB, is that correct?
That's correct, Chief Justice.
And you practiced as an attorney for a number of years.
Yes.
About how many years altogether?
Well, post-admission, I've practiced for 22 years before
22 years.
I got elevated to the bench.
Yes. And you got appointed to the bench when?
It was January 2017. This is after acting as a judge from 2015, I beg your pardon, 2014, 2015, and 2016, but not continuously.
Yes.
Yes.
You practiced at some stage for your own account for your firm, but at another stage you were with Cliff Decker of Mayor, is that correct?
Yes, I practiced for my own account from 1996 until
2012?
2012, that's correct.
Yes.
Yes.
That's like, is it 14 years?
For my own account? Much longer than that.
Much longer than that?
Yes. 17 years.
To 2012?
Well, from 1996
or 16
to
years?
2012, it was
16 years.
16, 17 years.
Yes.
And then 4 years
with
the larger law firm, yes.
Yes. Would you like to share with the Commission the breadth of your experience before you came to the bench? What branches of law were you involved in?
Thank you, Chief Justice. I believe I occupy a rather unique place because I started a commercial practice in 1996. And as I had indicated before that, I was working for a law firm that was steeped in human rights and also aspects of the development of the Constitution. And within that firm, which is Cheadle, Thompson and Haysom, and as I've said, they started a small department where trade unions were engaging in various transactions. And I worked with one of the respected partners, who's now the president of the Competition Appeal Court, in some of those very early BEE transactions. So I got exposed not only just as a fellow at CALS in some of the debates around the Constitution, and also as an academic support program lecturer in labor law. I then got exposed to human rights law, and thereafter started to get involved in those early transactions where trade unions were taking stakes in companies. Once I left Chidel Thompson and Haysom to work in Pietermaritzburg, the branch office in Pietermaritzburg, I continued my work in labor law as well as certain aspects of human rights. And then I started my own practice in 1996. And that practice was founded on, and I keep saying, on the back of Transnet specifically, because I started to get involved in property law. And I forgot to mention that the early debates around separating the Port Authority from Transnet and the various divisions, I was advising in those matters. And my firm expanded exponentially, and we took advantage of the thinking around Black economic empowerment, and we were advising smaller companies who were entering into transactions with the larger companies by way of various joint ventures and the like. And my practice also expanded to work with various sectors of the private sector, like the business partners, in relation to litigation, as well as some of the oil majors. Things did improve further in the sense that we got called in some of the early transactions where we were to be doing due diligences. And I've got in mind the old debates around SAA Express, for example, and the electricity restructuring. We were at the cold face of those discussions when they were looking at regional distributors. I got engaged in municipal law from the point of advising around certain infrastructure projects within the municipality. I served in the Best Practice Commission of the City of Durban when they were looking at the impediments to investment and some of the legal framework that is stymieing investment within the city. Side by side with that, I then got involved with various boards in shipping, in retail, in investment, and all that. And that really created this broad foundation of understanding the various business structures, the various models for business structuring. So early 2005, I got called by ESCOM, incidentally, to work with one of the renowned experts in the area of corporate governance. And that's when I commenced my foray in the area. And that work is not just fuzzy, it is taking the legal imperatives and translating them into systems of governance within the companies. So I started to work with various boards in that area, and thereafter, I got involved. I was called in as a fellow at the business school at the University of Stellenbosch, where we started a unit for corporate governance. And we worked with one of the renowned experts in the area to start the center. And when you hear conversations, for example, about ESG, which is environmental and social governance, I'm amongst the people who first proposed that for the PIC, where we devised a rating matrix system for some of their companies top 40 companies listed on the JSC. So I got involved in a range of areas which really give me insight into not just commercial transactions, but some of the thinking and the structuring of most companies in various sectors. This is before I joined the bench. And then there was obviously the compliance component of it, where you would take, for example, in the mining sector or in retail and so on, where you assist companies with their compliance projects, which is a top-down approach from the board right up to the risk teams. And lastly, I mean, I happened to also be involved in aviation from the perspective of being a non-exec at AXA at the hit of the World Cup and so on. So broadly, I came with that broad understanding.
Yes. Now, over the years that you have been a judge in the High Court, in what branches of law have you given judgments?
I think a variety of matters. I've written on property law. I've written on enforcement of securities, which tends to happen in urgent applications. I've written on enforcement of foreign judgments. I've written on shareholder disputes. I've written on business rescue. I've written on insurance. I've written on reviews, both under parja and legality. I've written on procurement. I've written, and I'm just trying to run through I've written on customary law. I've written on family law. I've written on civil litigation broadly. I've written on unjustified enrichment. I've written on contractual disputes, to mention but a few of the areas I've written on.
Well, that didn't sound like a few, but you must understand that the purpose of this question is to enable you to show the commissioners what the breadth of your experience, judicial experience is.
Yes.
So if there are other branches where you have given judgments, tell the commissioners.
Thank you. I just need to find my feet and remember what I would not have mentioned. I think by and large, I've mentioned the areas. I've written on criminal law, obviously, and then civil litigation, various aspects of around contract enforcement, and RAF, and those areas.
Okay, all right. Now, you have acted in the Supreme Court of Appeal over a number of times. Is that correct?
That is correct. I got an opportunity to spend a year, in fact, as I had said the last time.
Did your acting stints in the Supreme Court of Appeal give you exposure to other branches of law to which you had not had exposure at the High Court?
The one area that springs to mind is trademark and trademark law, and I sat in two matters at the Supreme Court of Appeal where there were disputes regarding the registration of a trademark, and which I really enjoyed it tremendously. Yes.
Yes.
And the other was a huge infrastructure project, but because I come with that experience around financing and structuring some of those, I also sat in that matter, which was one of my first big matters at the SA.
Would you like to share with the commissioners your understanding of the doctrine of separation of powers?
Yes. If I recall, I know that there may have been many judges of the Constitutional Court which have written around this. I think Judge Noble comes to mind in particular when he talks about this relationship of comity between the various arms of government. And as I understand it, what it really means is that within the Constitution, there are delineated responsibilities for each arm, and also with that, the powers entrusted to each arm, and that the judiciary needs to respect the delineation of the powers and not unduly encroach in the powers, for example, the powers of the executive and so on, and vis-a-vis.
And the rule of law?
The concept of the rule of law, as I understand it, is that all conduct and all laws are really subject to the Constitution, and that is the pervading principle that regulates all of us, citizens, government, the judiciary, and everybody is subject to the Constitution and the rule of law.
Thank you, President of the SCA.
Thank you, Chief Justice. Good afternoon, Justice Siwendu.
Good afternoon, President.
Yes, you acted at the Supreme Court of Appeal for 5 terms. I think it was 5 consecutive terms.
That's correct,
Yes,
President.
yes. How was the transition for you from being a judge of the High Court to being a justice of the Supreme Court of Appeal?
I think I did indicate last interview that the first 2 months were really difficult for me. And the difficulty was not the work itself, but we'd come out of COVID and we'd been working from home. So the difficulty was adjusting to Bloemfontein. I really got very sick those first 2 weeks, but that didn't impede my work. But the other is obviously working with larger teams and larger panels, and I think for those first two months, being trying to sense into the unwritten rules and unwritten expectations, and trying to get to know the system. But once I went over that hurdle, which is really a personal hurdle rather than an intellectual or ability hurdle, I was able to find my feet. And I really, towards the end, I really enjoyed myself and feel that I acquitted myself well in relation to the expectations.
Did other colleagues have to give input on matters of substance in relation to your judgments? I'm not referring to style issues or cosmetic issues, but where the judgment that you had circulated had to receive a lot of attention from other colleagues,
No.
specifically in relation to matters of substance?
No, not at all, not at all. And the commission will remember even the last time I did say that one of the areas I've really had to work on, and I think I've now come into firm grips of that, is the style of writing for the appellate court. But when it comes to matters of substance, my judgments were never, had to be reworked. And I don't believe in any way that I was in any way a burden on the presiders there.
Yes, I note that you have been a permanent judge for 7 years.
That's correct.
Yes, and you are probably aware that the SCA has lost a lot of experienced judges due to attrition and some retiring and others being elevated to the Constitutional Court. In fact, the amount of experience that has been lost over the last 4 years, 4 years, I think it's more than 100 years of judicial service, so it's quite a lot.
Well, if I remember it was said 340,
Yes, yeah.
340 collective years.
Yeah, that was, I
Yes.
think, from 2019 or
From
so,
2019.
but it is quite significant, you agree?
Absolutely. It is absolutely significant.
Yes. So
And-
you'd agree that it would be absolutely crucial for that kind of expertise to be replaced with almost similar expertise. In other words, expertise that will actually complement the remaining expertise on the bench so that the court remains a well-rounded court.
I've thought about this a couple of times, and I'm just going to go back to my answers to the commission the last time. I've gone out and I've done my own research in terms of how the court has evolved. And I've found that it's not the first time that the SCA is at an inflection point. There was a time, whether it was because of transformation imperatives or whatever, that it seems to have adopted this principle of infusion in the sense that what I know for sure is that once the longer time you have in the judiciary, you obviously gain the technical skills and the experience. But because law is such a dynamic field, I saw that a couple of times they've appointed, together with experienced judges, judges would say, we've been at the High Court for 3 years, in some instances 2 years, in some instances 5 years. And so it's not unheard of for the court to build a complement of skills. The way I have seen it in this instance is that in most instances, the skill set that is left has stayed there for 20 years. And therefore, the opportunity to refresh got stymied and got limited. And I'm not going to dispute, absolutely, experience is important, experience is critical. But the renewal and fresh thought and fresh thinking sometimes is necessary to keep the law dynamic and responsive to social needs.
Yes. Lastly, you'd agree that the appointees must be candidates who are going to, in some way or another, address the current needs of the court.
I agree.
Yes. Sorry, Chief Justice, I had said the last point. The last point is this one. Would you agree that collegiality is important at an appellate court? I know that we do sometimes in the High Court sit in panels of 2 or 3, but in the Supreme Court of Appeal, there will never be a case in which you will sit alone, all by yourself, which happens in the High Court. Would you agree that that is the very reason why collegiality is so crucial at the Supreme Court of Appeal?
I agree, President, entirely and wholeheartedly. And my view is that that gets tested when there are different perspectives and different points of view. And collegiality is such that it's so critical so that one can accommodate different perspectives. And I've found that it only just but enriches the judgment. It only but enriches the thinking around the judgment. And that's where it's like a family. You know the tightness of a family when it is able to resolve, disagreements collegially. Absolutely.
Thank you very much, Justice Siwendu. Thank you, Chief Justice.
Thank you.
Thank you, Minister.
Thank you, CJ. I've got no question.
Thank you very much. Commissioner Marmohai.
Thank you very much, CJ. Good afternoon, Judge Siwendu.
Good afternoon, Commissioner. Maria.
In the list of areas that you have written on, you left out one important one. You have also written in pension law. And
I've also written.
in pension law.
Oh, yes.
Yes.
In the context of review, in the context of reviews, yes.
Yes,
I
but it
have.
went further than that, and that's what I want to discuss with you.
Thank you.
Can I refer you to pagina? The way they are paginated, it's as if it's case line, and they have two paginations. Like there's one on the right and there's one in the bottom. So on the right you'll have 160 at the top, and I think at the
Just
bottom.
160.
Yes.
Actually, now that you are making me page through, I've forgotten to mention that I've also written on restraint of trades.
Oh yes. So
Yes,
page
160.
160. It is a Southern Sun judgment.
Yes, yes,
Yes.
yes.
This is where the fund applied to distribute or to apportion surpluses, and
Yes.
the FSCA was against that because beneficiaries could not be located,
Yes.
and you dismissed the fund's application, right? And what I don't understand is when I look at paragraph 28,
28.
of your judgment,
Yes.
when you dealt with the regulation, you seem to have approached them. I'm not sure if this is how it was pleaded, but you seem to have approached this matter from an administrative law point of view, and PAJA in particular. I'm not sure if you are aware that this matter was actually subsequently appealed to the
Yes.
Supreme Court of Appeal, and it was overturned.
I've listed it in my
Yes.
list of judgments, yes.
And what I like, the way you determine the issues and the way the Supreme Court of Appeal determined the issues or determined what the main issue was seems to be different. I'm not really sure if the case evolved when it went to the Supreme Court of Appeal. Because what in paragraph 2 of the Supreme Court of Appeal's judgment, they are saying the question that they are seized with is whether the regulation in question is ultra vires the powers assigned to the minister in terms of the PFA. So they seem to find their root within the Pension Funds Act, and quite correctly so. So my question to you is, to what extent disputes that arise within the context of the Pension Funds Act in particular can be resolved in terms of administrative action?
First of all, maybe let me just, let's walk it back and take a little step back. If you read the judgment, there were a series of issues that were raised. The first hurdle was around a dispute of whether this is a PAJA or a legality review. And then the second hurdle was the question of the extension of the time within which the application was launched, right? So I had to first go through those hurdles, and that's what you obviously see under in paragraph. The last hurdle was obviously whether or not the regulation is ultra vires. So all of that is dealt with. And I think the significance, if you go to the list of judgments that I have given, the significance of this judgment is that I point out that there were a triad of matters where the core issue, the core dispute about the reviewability of the regulation was challenged, but those issues were not addressed. And the Supreme Court of Appeal didn't overturn my exercise of the discretion to deal with the merits. So I had to systematically, obviously, as a first court, address first all of those issues before I get into the merits. And that's why they were distilled that way.
I accept that. When I was reading because I actually got to read the Supreme Court of Appeal judgment first before I went to
Yes.
yours. So I was just it was quite interesting how the Supreme Court of Appeal framed the issue. Because when you look at that judgment, they don't actually deal much with PAJA per se. They instead, to some extent, deal with the principles of legality.
Yes, yes.
And they don't concern themselves too much about the administrative law part. And there's a reason for that. when you look at the scheme of the Pension Funds Act and how it is actually designed, you are able to deal with disputes that arise. Section 15B of the Pension Funds Act
Yes.
deals explicitly with surplus apportionment.
Yes, I don't disagree.
Yes.
But all I'm saying is that you must remember that there were triad of matters. There were
Yes, you are
actually
correct,
three
yes.
matters. There were three matters involving the
Yeah.
same issue. And so my judgment opened the way for the SCA to get into the merits because all of the other matters were dismissed, even though the court had given an arbiter judgment, they were dismissed on the reason of the extension and without dealing with the merits. So they had to first deal, and they accepted my exercise of discretion so that they can, and even this judgment, even though it was set aside, it goes into the surplus apportionment, it goes into the regulation in terms of what was envisaged in terms of that surplus apportionment, and it deals with the ultra-various issue. And of course, there was an argument about the reasonableness, which was not the basis on which the matter was brought. So towards the end, the judgment deals comprehensively with all of those issues. And I accept my reasoning was set aside.
No, thank you very much. It's actually set aside the regulation itself.
They set aside the
Yes.
regulation itself, yes.
No, thank you very much, Judge Siwendu.
you.
Thank you very much, CJ.
Thank you, Commissioner. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice Siwendu.
Good afternoon, Commissioner.
Yerema, yes. In all the branches of law you mentioned, you didn't say anything about the insolvency law.
I forgot to mention,
Have you written some?
yes.
Yes, okay. If that is the case, I want to test your knowledge on the insolvency law because I've seen that a lot of people are found wanting when it comes to that area of law.
Yes.
Now, what is the basic test of insolvency?
You must remember that, in fact, one of my latest judgments on that is, I think I've given it's 93 quarts, APSA versus 93 quarts. Remember that the act, the jurisdictional requirement is an act of insolvency. And for companies, that's determined by just 345 of the Old Companies Act, which deals with the failure or inability to pay debts.
Yes, okay.
Yes.
That's clear.
Yes.
Now, linked to that,
Yes,
Section 8 of the Insolvency Act
yes,
provides the circumstances under which a debtor can be declared insolvent.
yes,
Would you mind sharing that with us? Because
yes.
if that obtains, it becomes a candidate for, a debtor becomes a candidate for sequestration.
Yes.
What are those?
Yes. So remember that we've got two regimes. There's the regime of liquidation, which is regulated by the Companies Act. And then there's the insolvency regime, which deals with partnerships and which deals with sequestration of individuals. And I think it's Section 8, A to G, there's the Act of Insolvency, failure to pay your debt, or escaping or leaving the country with the intention to evade the payment of the debts. I've forgotten some of the other requirements, but those are mainly the two that come to mind.
Actually, you nailed it. Thank you very much, CJ.
Can I follow up, CJ? Can I, CJ?
Yes.
Yeah, this side. Can I
Oh,
follow
yes,
up?
yeah.
Just when that question that Commissioner Dodovu asked triggered a question of mine. I just want to understand. When you are dealing, and by the way, I'm currently writing a case note on your ABSA Bank.
I beg your pardon, you are?
I'm currently writing a case note on your ABSA Bank
Yes.
case. Right.
Yes.
I just want to understand. When you are liquidating a company,
Yes.
is your source of insolvency in the actual Insolvency Act and in Section 8 that Mr. Dodovu is speaking about? I got confused there.
No, it's not. Let me explain again. You must remember what's happened is that the New Companies Act creates two regimes. There's the winding up provisions. When you are winding up a company, which is different from liquidating a company. So when you are winding up the company, there's a whole criteria for winding up provided under the New Companies Act, which can include disagreements between shareholders and whether it is just and equitable to do so. But when you are liquidating a company, Schedule 9 or Schedule, I've forgotten now, I've gotten muddled. But what that schedule says is that liquidations of companies is regulated by the old Act. So the provisions relating to liquidation of companies, so you've got this straddling between the provisions of the new Act and the old Act. So all liquidation of companies occur under that chapter 14. And all of those provisions apply to liquidation of companies and the process of liquidation. So there's two different processes, the winding up and the liquidation. And under the Insolvency Act, you are dealing with mainly sequestrations. Yes.
But even with liquidation,
Yes.
the 1973 Act deals only with the liquidation of insolvent companies.
Yes.
And the New Companies Act deals with the liquidation of solvent companies.
No, we don't call it a liquidation of solvent companies. We call it a winding up of solvent companies. Because a liquidation envisages a scenario where the company is unable to pay its debts strictly. So the new Act deals with the winding up of companies, not their liquidation.
Yeah, I think no, I hear you.
Yes.
I hear you.
So
Thank you very much.
I'm trying to be strict in the distinctions. Yes.
No, thank
that's
you very
fine.
much. I won't take it further than that. Thank you very much.
Don't, it's becoming more than a follow-up. Commissioner Moiman. I've got Commissioner Moiman, Commissioner Singh.
Yes.
And except for complaints or objections, I think I'll stop there. Okay, Commissioner Moiman.
Thank you, Chief Justice. Good afternoon, Judge Siwendu.
Good afternoon, Commissioner.
It's just one question from my side that emerges from the new company regime that is anticipated.
I beg your pardon, I didn't hear that well.
I'm saying that my question relates to the new mining regime,
To the new?
to the new company law regime
Yes.
that is will probably be signed by the president because it is on his desk.
Yes.
Yes, it relates to. I need to get your view in terms of the changes that were brought to the time bar, which allows the recovery of loss from the previous directors of company.
Yes.
It's in relation to, it's the response to the state capture report. So Parliament then made amendment to the Companies Act. So I needed to get your view in relation to the changes that allows for even the directors that might have left the company, let's say 10 years ago, to be held responsible for the losses that the company might have incurred. That's your views in relation to that, because it's part and parcel of ensuring that directors are held accountable in terms of the work that they have done. Thank you.
I must confess, I haven't studied carefully the proposed amendments because of time. But what I am aware of is that under the current regime, I mean, the whole company law is premised on a separation from the corporation and shareholders and directors and a delineation of different duties between the two. If you recall, if you will remember, Section 76 then creates a statutory duty of directors and in a number of ways codifies the common law position around the statutory duty. And I know that very recently the SCA has produced a judgment around this issue as to whether an aggrieved or an affected person can go directly and sue the directors for losses sustained by a company. And if I understand that decision, the answer is definitely no. There's recourse obviously elsewhere, and I think understandably, because unless, for example, the directors have been declared delinquent and all of that, you can't just go direct. So if legislation is intended to alter that position, but I can confess that I have not had the opportunity to study what the import is of the new amendments, particularly around directors' liability. But of course, the legislature is entitled to amend the Act and create different duties from those that are codified under Section 76 and 77, and also those which are applicable in terms of common law. It's within its powers to do that.
Yes, I think you are correct because the amendment to Section 162, 1622 and 1623 is particularly aimed at amending the time bar for bringing an application to declare a person delinquent in terms of the mentioned section that I did.
Thank you.
So it is aimed at bridging that gap. Thank you, Chief Justice.
Thank you.
Thank you very much.
Siwendu.
Commissioner Singh will be the last one. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Justice Siwendu. I'm on the virtual platform.
Yes, thank you.
I just want to refer to your time on the special tribunal.
I beg your pardon?
Now, your time on the special tribunal.
Yes.
And I have two questions arising from your participation in the tribunal.
Yes.
Firstly, how effective do you think are special tribunals of this nature and why? And secondly, what experience have you gained from serving there that you think will hold you in good stead in the SCA if you are appointed? Thank you.
It's a very difficult question to answer in terms of effectiveness, because the executive has chosen this path, and I just need to be careful about how I answer that. I think part of the problem is that when you create a tribunal, it's not a court of law. I think the Constitutional Court has dealt with this in Ledler, and to say that the tribunal is not a court of law, even though it has been given these powers. And there is merit in having a specialized structure which is designed to fast track the investigation and dealing with some of these cases. My sense is that sometimes you are competing for the same pace for resources to be able to deal with this. When, as we've seen it, you can create a structure within the High Court to do so. That's the one question that I've raised. My duty there was around with the other senior judge. We wrote the rules, we wrote the code of conduct. I wrote the first report, and I said in a number of cases where there were asset forfeitures, which were really interim relief and preservation orders. And beyond that, I was taken back to the High Court. So it is more around the awareness of how POCA operates and how it interfaces with the SIU Act. And beyond that, really, I don't know that, and the awareness of how tricky sometimes that interface is. And beyond that, I can't add more.
Do you think that the fact that you had to work with others there, as you would have to work in the SCA, will hold you in good stead moving forward?
You know what? I am a deeply felt self-reflective person and probably more introverted than I'd like. So I'm a deep thinker, I'm thoughtful, I'm reflective, and I'm particularly sensitive. Social context sensitive and sensitive to others. And I am a very mature person. So I know how to manage myself, especially in the space of disagreement. And I think that awareness will come in really good stead. And just like the president wants to see the best court, I think that I'm going to be able to contribute to the spirit of collegiality, and especially when things get difficult. I'm a very self-restrained person.
Thank you, Judge Siwendu. Thank you, Chief Justice.
Thank you very much. That is the end of this interview. Thank you very much, Judge Siwendu, for availing yourself for consideration for appointment to the SCA and for coming to this interview. You are now excused.
Thank you, Chief Justice, and thank you to the Commission.
Thank you.